the Warren Court into a fount of justice that we've retreated from. And I'm overstating this bit. And the answer is, I did overstate it. I don't think it's necessary. I don't think fixing exactly what the Warren Court's intervention amounted to really is A, possible, or B, necessary to the way the paper works. But I think it's fantastically interesting, and we should talk about that, because I think figuring out what constitutional interventions, even in the most celebrated sort, like the one we saw in the Warren Court, really amount to is extremely hard in any context, but I think particularly so in the criminal justice context, where, as I guess Pascal was pointing out, constitutional law gets practiced every day in little increments in all the counties and criminal cases scattered across the country, and arguably every time the police take somebody into the station house to have a conversation or interrogation. So it's a challenge to all of us, and I don't think, at least in the United States, we've ever fully met the empirical methodological challenge of figuring out what decisions from the Warren Court really amounted to. Some of it's easy. You can count how many lawyers get provided. So, you could figure out how many jurisdictions did it before Gideon, how many, what was the incremental addition after Gideon. But were they good lawyers? How were they recruited? What are they doing? What was the qualitative effect of that intervention? Frightfully hard. Search and seizure. We know that the exclusionary rule comes in force. We know that as a result of judicial decisions, the Fourth Amendment gets applied to state operatives across the country. But the conversation that I was having with Karen Elizabeth is, yes, but to what extent is it this matter of internalization of Supreme Court norms versus circumvention of Supreme Court norms? And we have our stories, we have our views. I'm not sure we have a very, and certainly I think increasing work is being done on the empirical side to try to get a handle on these interventions. I don't think we've done a fantastic job. And it's sort of a reminder of the challenge of comparative constitutional scholarship generally, particularly when you're looking at another country's work. You have their judicial decisions, you have the public space conversation about those decisions, but figuring out what those decisions amounted to on the ground, particularly in the criminal justice system, is hard. We know if the Affordable Care Act had been struck down, a legislative program could not have gone into effect. We know certain things, and we know whether somebody's executed or whether someone's not executed. One of the things about capital punishment is there's a granularity, even though there's still large numbers, but searches and seizures, trials, I'm not sure. And it really makes me feel humble about doing any discussion about criminal law in the constitutional sense whenever I'm faced with a question like that. So the short answer is, I'm assuming that the Warren Court had some effect. It certainly was said to have a great effect. Was it of a real sort of qualitatively different kind of brush than the ones I was portraying? I'm not sure. You could push and maybe say it was more like a collaborative project, or you could say no, it was just sort of articulating this little miniature that the police can circumvent. I don't know.
So if we look closely at your three brushstrokes, right?
Yep.
The third one, sweeping structural ambitions reminiscent of the Warren Court. So that would be the one that you would think.
Yep.
But today it entails considerable reliance or collaboration with other regulatory authorities. So one question would be, was it that the Warren Court did not entail those collaborations, which to a certain extent they did.
Police practices.
Certain
For police practices, I did. I mean, one of the things, and I was talking about this in Miranda, and one of the, I guess, it's a little ambiguous in the paper, because I said it is, Miranda was in a way collaborative, in the sense that one of the sources of confidence on the Supreme Court's part that Miranda would not, nullify the ability to prosecute and interrogate was that the FBI was doing this. That makes it sound more like a type 3 case than a type 1 case.
Like Duncan.
Right.
It's different. The jury trials.
When you're talking about juries, that's right. Institutions that are either there or not there. So juries are either there or not there. Lawyers are either there or not there. Outside of that, it's harder to really identify what effect the Warren Court had. I think just given how old it was, how long ago it was, there's an inherent collaborative aspect. Anytime the Supreme Court speaks over time in a dynamic system, you're going to have internalization and backlash and the like. So I'm not sure. I think people have created the Warren Court as a qualitatively different source of constitutional norms. And you're right, I think that's probably an overstatement, but I'm not sure how much of an overstatement it is. And the question becomes, to what extent is it really much the same as what we're seeing now? I think the court back then thought of itself as coming to a new field. I mean, criminal procedure in the United States is only a little bit older than I am as a constitutional matter. You really didn't have criminal procedure in a grand sense in the United States done at the constitutional level, except for just, 1 or 2 cases picked up.
What date are you thinking of?
I was born in 1958.
So which date where do you think constitutional criminal procedure began?
I think it starts to begin in a serious way in the 60s.
So you're older than it.
Yes, but I didn't want to push that.
I'm just trying to get the date here.
About the same. Okay, for the record, I'm old. And, I think the Supreme Court saw itself as moving to a new turf. In part because between habeas and incorporation, these were new languages that were being spoken, and they don't have the effects that we think of them in some of our rhetoric in terms of changing the world. But I do think they were writing on a new slate.
Habeas did have huge
Habeas.
effects. They counted the number of cases that went to federal courts, thousands more.
Right, and the combination of habeas and incorporation just has this. All of a sudden, the Supreme Court is in this business. What we take of as a standard part of its docket dates to around, the 60s, between incorporation and habeas, and the two are obviously related.
Let me ask you a question related to this. You've made a very strong case that the more recent decisions have basically a very little effect.
Right.
I mean, there may be nice rhetoric, but in the actual practice, are these initial decisions different, or is it what is different is that there was a blank slate, all of a sudden we read Gideon, we read Mapp, and so those of us who are naive and outside of the criminal area and think that constitutional decisions matter say, look how the United States is now behaving very differently than it did before, when in fact Mapp and Miranda were incorporated more or less, and the actual change for the little defendant in a county in Alabama is not very different.
That's a great question. And so in a way was this a qualitative change or a qualitatively different change in the Warren Court compared to sort of this quantitative easing or tightening that we're seeing now? My sense, and this is not something I wrote about, but it's something that it'd be nice to talk about. My sense is that it was qualitatively different, that we talk about Miranda as being circumventable, or put differently, Miranda as being something that gave bright-line guidance to police officers that they could easily internalize and didn't stand much in the way of law enforcement. On the other hand, having law enforcement officers around the country mention the idea of the Constitution being present in a station house is not true. I think the idea that there was, even if it not very well connected and not very well run, a norm transmission belt that went from Washington to a station house in Alabama, he might still beat you. He might still violate Miranda, but he said it existed, or at least we're going to let later on.
This has something to do with kind of relations of power, I think, to a certain extent. I mean, in other words, it's not as if the Supreme Court, through its Warren Court jurisprudence, could change relations of power in the South. Couldn't. But there was, nevertheless, a significant change in the sense that the court as a presence was there as a potential tool to use, right? As a reference point, as something that you could use on your side.
I also think Danny's right that it changed the conception of law enforcement's relationship to law, to a higher law. There's this great, I forget like which cop show this scene is on. I think it might have been way back with Hill Street Blues, or it might have been past that, a TV show. And there's a scene where the police were interrogating some person they suspected of a terrible crime, and they couldn't get the guy to confess. And then the lead police officer, the guy with the red hair, what's his name? You know, who's now like,
Bald?
anyway, no, probably. Anyway, famous actor plays the lead.
New York City.
NYPD
And
Blue.
NYPD Blue, right?
NYPD Blue, that's what it is, NYPD Blue. So they're trying to get this guy to confess, he doesn't confess, and he's teaching a young police officer interrogation techniques, it's not working. And so he says, sometimes there are cases where he takes off his badge, takes out his gun, leaves them on the table, goes into the interrogation room and shuts the door. And we are supposed to know what happens then. He threatens and beats the guy, comes out with the confession. And it's supposed to be a kind of symbol that he leaves the sign, his sense of himself as an official law enforcement agent. The law stays outside, and he goes in and lawlessly, but the question is...
The truth comes out lawlessly.
The truth comes out lawlessly. But that very idea that you take off your badge and leave your gun outside when you did this is like completely the creation of the 60s. The idea that there's this sense that it's... Yeah.
And to follow up, and this adds to what Carol said, I think particularly in the United States, where you have a criminal justice system that is A, local, and B, elected, what the Warren Court does is start having this notion of law and politics being a little bit separate in the criminal justice context. If you think of the police officer just reporting to the mayor, and the judge used to be the DA, and maybe tomorrow he's going to be the mayor. These are the same people moving around. There is the idea that law has a role to play that goes beyond elections and sheer power may be largely aspirational, but it was real, I think, at the time. And I have no way of showing that.
And the other question this raises really is, because I keep on thinking about the structure, the framework within which we are, which is this idea of these structural transformations. The first wave in 1789, 1776, second wave, which in Europe is more post-World War II, third wave with the fall of the wall. Which doesn't fit, as I try to suggest, doesn't fit that well with the U.S. case. What was it about the 60s? We tend to think of it in the U.S. as the civil rights movement, or the response to the civil rights movement, or the instantiation of the civil rights movement in the 1960s, which was probably the last structural transformations of constitutional law. Incorporation as being a structural transformation of constitutional law.
And habeas.
And what?
And habeas.
And habeas, right. So in the early 60s, there isn't a similar phenomenon in Europe, I take it. I mean, so what was it in the 60s that was going on in the US that would create such a structural transformation at that point?
Two revolutions have taken place in Europe. And one is very much runs along the same lines as the criminal revolution in the United States. In the 60s, if you look at the case law of the European Court, the Strasbourg Court, the European Convention of Human Rights.
Hi, come on in. Sorry. Come on, Rick Brooks from Columbia. Thanks for coming. And Sadat Sanga from Columbia. Postdoc. You're done now. Yeah. Done. Welcome. Does everybody know each other? Sorry to interrupt. Brooke, then of course Elisabeth Zolet. Student, PhD student. Carol Steiger. Jean-Louis Alcorin, who is at l'École Normande Supérieure. You guys have met? Yes. Pasquale Bosco, who's at NYU. Olivier Keda, who is at the École des Hautes Études. Mesma Saint-Hubert, who is organizing all of this. Michel Tropper,
Sadat Sanga. Columbia.
Who is going to be a fellow at Columbia this year. And Michel Tropper, is it? Rick Brooks. Sorry.
So I was saying that Bernard asked us whether there was a similar evolution in Europe regarding the criminal revolution in the States in the 60s. So I just copied my answer as back to the group. And I said that there were two revolutions that took place in Europe in the 60s. And both of them came from the European Court of Human Rights, I mean the Strasbourg Court. One was in the field of procedure, legal procedure. The court, started an attack against administrative tribunals. Against the process followed by administrative tribunals in the 60s. It's a complicated story, but basically the idea that it was not a fair trial, basically. But that was just the beginning, and the shock wave would come later on. But the second revolution, which by far, in my opinion, is much more important, was the revolution of freedom of expression. And that started with in the early 70s with a case on the Handyside, a so-called Handyside case. And that was really a shockwave on the European states because, to make a long story short, of course, and making the story very, very short, but basically the European Court followed after the Supreme Court regarding free speech. And the freedom of the press, freedom regarding pornography, sexual expression, which was very much under censorship in the early 70s. You remember the day, we've probably forgot those days, but I'm sure that Michel has not forgotten the days when la religieuse de Diderot, la religieuse de Diderot was forbidden. Because it was Diderot and it was la religieuse was forbidden. So all of that was set crumbled in pieces. So yes, there was. So I've always thought, as far as I'm concerned, I've always thought that there was cross currents between. This is why I insist so much on human dignity, because I do not think that the Supreme Court and the stature that it occupies and the place that it has in the country can remain completely foreign to this idea that is also pervading, the entire international legal system, and say we don't know anything about it. I don't think that makes sense. For the leadership of the United States, for the stature of this country, for me, it's totally. I cannot square the two pieces of the pieces of the puzzle. And conversely, the European Court was extremely influenced by the common law procedure. I think that common law in the procedure, legal procedure, in most the Germans had done their revolution much before because they adopted the constitutionalized administrative procedure. But mind you, when I entered law school, we celebrated as a huge victory a case by the Conseil d'État that we call Société Maison Génestale. And in that case, what did the Conseil d'État say? It said basically to the administration, when you refuse, when you turn down a request from an administrator, you've got to say why. You've got to give your reasons. And that was in 1968. And we celebrated that as a huge revolution. Huge revolution. So it's to show you, the impact of the common law procedure, of the fair trial, on the administrative procedure. That was really, a shockwave for me. See change in public law. This is why we no longer have a public law and a droit public, puissance publique. It won't fly. It no longer flies. I don't know what Michel thinks about that, or Pascal. I don't know what you think, but for me, talking about that puissance publique,
But maybe then
nothing.
what I could propose then, or suggest or something, is that in our thinking about the kind of constitutional structural changes, there was maybe also a moment in Europe, or at least in France, and I don't know about other European countries, in the 60s, as part of the social movements that were taking place, that were structurally transformative in a way. I don't know if you have developed that in the context of neo-retro, but maybe there was it sounds as if there may also have been some important structural doctrinal changes at that point that had importance in the way they did in the United States. Because I really do think that for the United States is a doctrinal / structural change with incorporation, etc.
Well, I'm interested in this idea of cross currents and the transatlantic influences that you're talking about. And I wonder if when those transatlantic influences began, and I wonder if there's the 1960s were a time when cultural influences were really strong. There was a youth movement and an anti-war movement and an egalitarian movement that was transatlantic, that was, we were seeing very similar kind of social phenomenon happening simultaneously. And I wonder, for you comparativists, whether that was a moment where these legal and institutional cross currents became stronger, and if there's some link between those things, or not.
There is, I think, one broad link, which is sort of post-colonial crisis. And in the United States, in France, clearly after the war in Algeria, that led to the 68, the end of a generation, de Gaulle representing the sort of the good guys in World War II, came to the end, and the student movement, workers movement. In the United States, I view it as the internalization of the civil rights movement. According to some historical accounts, Brown v. Board of Education, which is one of perhaps the way out decisions of the Supreme Court, we talk about tracking public opinion, was a concession by the intellectual elites that you're going to lose the Cold War because the other side is showing the United States great country of freedom, equality, etc. And then they show it's totally simplistic, but there have been books written about this. But this didn't work right away. The resistance, Brown II, and the failure, which led to the failure of integration, and then led to the Civil Rights Movement, the Voting Rights Act, the new Kennedy era, I mean, all this coming together, then the Vietnam War. So we are in a year, plus the war in court throughout all this. It's a moment of change of generation, some hope, some rebellion, some, all of that. And there's some parallels between the European and the American, and I peg it at colonial, it's the one element in common, although in America it's internal, in France and the other European countries is losing your empire.
We do our colonialism at home.
Okay, so we internalize colonialism. Whatever it is, I think that's the mood of the moment that does have important constitutional consequences throughout or at least across the Atlantic.
And do you think that generated, am I right that the 60s and 70s were a time of more attention paid to legal change across the ocean between the US and Europe?
Well, in this, Elisabeth can either say I'm right or wrong because she knows much more about it. I mean, there's the beginning of, as you said, the convention of the European Convention being something real in real cases. If you follow the German Constitutional Court, a lot of major decisions from the late 50s and 60s, so you can certainly see a transformation in the German context. Whether other parts of Europe, I don't know about where the Italians were at that particular time in terms of its constitutional court or constitutional
Well,
life.
at that time in Italy, we became very attentive to what was going on in Washington D.C. because of Kennedy and in Berkeley because of the student movement.
But in Germany, I mean, to come back to the point that you made, in Germany, it started much earlier. Because the major cases, the major
50s.
German cases in the late 50s.
Yes, the Lut case in
instance,
58 is one of the main, the Lut case in
Yeah,
58,
the
yes.
Lut case, Mephisto.
Right.
Then afterwards, in the late 60s, Princess Soraya.
Yeah.
These were major cases.
Right.
Very, and again, I mean, influenced by the United States because Princess Soraya, I mean, is heavily in Lut too. I mean, is influenced by the civil rights movement in the United States. I mean, and the enforcement of the Constitution against private compacts, private contracts and excluding the banks. Yes, discrimination. Yes. So it's the same idea that you have this. The German, I mean, puts it in the very powerful idea that spread out, I mean, all over Europe, that the Constitution is radiating over the entire legal system, and that was also, I think, triggered by the European Court of Human Rights and encouraged by the European Court of Human Rights. And despite all the resistance of the souverainists, and what people would call today, I mean, the souverainists, I mean, it was swept off by the youth, totally disappeared. This is why I say, I mean, the puissance publique is no longer a viable vehicle. It's no longer a vehicle for anything.
But what happened in Germany could not have happened in France
Not yet.
before 1971 because
You're
there
right.
was
Absolutely.
no such thing as judicial
Yeah.
review of legislation.
Right.
So the jurisprudence of the courts did not matter really. Not
Right.
even the Conseil d'État or the Cour de Cassation. People were not aware of the language of the courts. I think it's Le Monde had on the front page mention of a decision by the Court of Cassation for the first time with Perruche. But before that, you never had in the French press any mention of any important court case.
Yeah, that's right.
And
So-
Perruche was what year again?
Perruche,
Perruche, c'était quelle année?
2001.
2001.
But the French Association decision was 1971, the one that supposedly was the French Marbury values and abuse a metaphor. But this raises the interesting question because clearly in the United States, the 60s are marked by, on the one hand, the war in court and the constitutional revolution, maybe too big a word, but change. And for the first time in the long time, street politics. I mean, the student demonstrations, Berkeley, Columbia, all that, and
And
the
riots,
and the Democratic, and the riots,
The riots.
the Democratic Convention in '68. I mean, there's a real uncharacteristic street life. Whereas in France, '68 was a street. It was the students, the workers, the burning of places, public places, and so forth. So, is there any constitutional dimension to this, or was it purely political?
None.
None of it.
None.
It was all.
First, because you can only do something about constitutional law through constitutional amendments.
I don't mean in a formal sense. I mean,
but
what were
in
the
any
demands?
sense, in any
The
sense.
only, Michel, if I may, the only constitutional underpinning of this revolution was the so-called the slogan 10 ans ça suffit.
Ouais. Et ça, c'est purely
Yeah,
political.
But 10 ans ça suffit, and meaning attacking, of course, the length of the mandate of the president.
So there was no vindication of rights
No.
as such, because
But
you
it
did have
was
constitutionally
against
speaking
authoritarian.
streets.
Yeah, but-
No claim about court decision.
Okay.
No.
No, what people wanted was a revolution, and you don't care about the law. And don't forget the importance of Marxism
That's right.
in the French culture of that time.
Yeah.
So law is just a superstructure, it
Right.
doesn't matter.
Yes.
And,
This is very true.
Because if Berkeley was called the free speech movement, so it indirectly at least had a clear constitutional connotation.
But the fact that, but then review is created in 71 or 72?
in 71, the Constitutional Council decided that it had the right to review legislation according to the preamble and to.
Meaning right.
But was that a product of 68 in any way? No. I mean, it
What
was
was
so,
it a product
so there was
of?
no.
What made that
No,
happen?
only very, very indirectly, because if you look at the, well, if you
fact,
look at the
was
case,
some-
it was la cause du peuple.
Allegedly.
Right.
Oui, c'est très indirect.
Yeah, well, but it was because of the
C'était
student
le
movement.
Au mouvement gaulliste, c'était
It's a question how to do
les gauchistes se sont.
with the student movement who created an organization to defend.
La cause du peuple. c'est
Yeah,
ça?
bien sûr. I mean,
But it's that.
Mais c'est indirect.
Non, non,
Well-
ça n'a aucun rapport. La décision du Conseil constitutionnel est due à des tensions internes au Parti gaulliste. Le Conseil constitutionnel était constitué et à l'époque il s'agissait de la présidence de Pompidou et c'est effectivement dans un contexte très très particulier.
Well, not only. I think that we have to be cautious in giving this straightforward tale about the decision of 1971 because the complaint was sent by the president of the Senate. It was sent by and OS, yes, and it was a blank complaint. So there was no arguments made. It was just sent like this to the Constitutional Council, saying that it was probably unconstitutional. And, you know, if you look at it from a strictly legal standpoint, there is some truth in that, because the law that had been adopted by the Parliament and was to be enacted as a positive statute restrained liberty of association, in fact, put prior restraint, you would say, a prior restraint on the legal capacity of organizations, of associations. In other words, to be recognized as a legal entity, you had to declare yourself to the prefecture and
If they had to authorize.
exactly, and get an authorization. So
And that was the law that was struck down.
that was the law that was sent to the
Sent.
Constitutional Council. Now, you may say, and this is what Olivier just said, and Michel too, that it was for the small associations like Sartre and Simone de Beauvoir and La Cause du Peuple, and you can say that. But, and this is, in my opinion, what makes the whole thing extremely problematic, not only for the political, the Gaullist party, but for the entire political class, because you could apply this law to any political party. You could apply this law to any political party. That meant then you could check, or you could have a check on the formation of political parties in the Republic. And that was, I think, a crucial point, from a purely legal standpoint.
Oui, pour les intérêts politiques en jeu, mais l'opération normative qui consistait à prendre une décision historique en France, d'incorporer le préambule au droit constitutionnel positif, à l'occasion d'une loi de la Troisième République et pour, dans une certaine mesure, la constitutionnaliser, est une opération qui n'avait pas de rapport avec le contexte politique et social de l'époque. C'était une opération tout à fait révolutionnaire.
I totally agree. No, absolutely. No, but we are talking about the underlying
prodigieux. Mais je veux dire, c'est, par rapport à la tradition juridique en vigueur jusque-là, il y a eu des circonstances politiques, il y a eu des intérêts politiques à satisfaire,
Yeah.
mais
I agree, Olivier, but there had been similar attempts before even 71, before
And there-
the Conseil d'État. Yes, the Conseil d'État referred to the principe des droits de la République. I don't remember exactly the term that they used, but you have Société des Anamites, la CLIC là, des années 50, le Syndicat national des ingénieurs français, also les principes généraux du droit, and all of that. So it was not a bolt, in the blue. It had some historic precedents. So it was connected also with De Gaulle was gone, so we had this dictator or this out of the way, so the Conseil d'État or the Conseil constitutionnel and the entire political class felt more freedom to breathe, so the political context was different. But I totally agree, it was a revolutionary act. Yes, absolutely. It was, et notamment because they could have reached the same conclusion, which is quite interesting, relying only on the pure constitution, relying
Yes.
within the four corners of the constitution. But they say, et notamment, so the whole thing is in the notamment. Why did they?
How could they have reached the same conclusion? What was the conclusion?
The conclusion was that the law was contrary to the 1901 law on freedom of association.
And how could they have gotten to the same conclusion without going back?
Probably based on Article 4 of the Constitution that provides for the parti politique s'exerce librement or something like that. Article 3 or 4, I don't remember the number, but I think they could have reached the same. Because there was, otherwise, there would have been no reason for a notamment. Notamment was indicates that you needed a supplemental, you needed an additional argument.
But the additional argument was probably the most important for them.
Oh, yeah.
Because that would give them enormous power
Yeah.
to
They
start
would-
reviewing legislation according to the preamble.
Yeah.
And the preamble is so
Yes,
very
and
vague
then-
because it refers to some unwritten principles.
Yes, and then it was
The
the
list of which
dream
is,
of the
indefinite.
center right. It was the dream of the center right.
And
So-
did the Constitutional Council begin to review many laws
Yes.
under this new
Or
power?
many laws, it would be
Now more and more.
more and more, yes.
And the dream of the center right, because the way they
Because we had a constitutional court.
This is interesting to me.
Because the libéraux in France, on la ligne de Tocqueville, they have always dreamt of the Supreme Court.
In the sense that it relates to, so at about the same time, there are questions of association that's happening in the U.S., which had always been very liberal with respect to for-profit corporations, but the non-profit corporations and the right of the state to regulate the activities came at a head in this Mississippi versus NAACP.
Yes.
And the court's decision there, and even now thinking about Citizens United,
Exactly.
where there was literally another route. There was a convenient route to get to an easy route
Mhm.
to get to the same end, but they took the more aggressive stance, really to, some people say, to sort of situate themselves to make a much more aggressive statement going forward about limits on campaign contributions as expressions of speech. I wonder if I don't know the French 1971 associational law context, But given that you know Citizens United, are there any interesting connections and things that we might be thinking about going forward in the U.S. based on your experiences post-71?
With Citizens United?
Yeah, I mean, of course, the Supreme Court doesn't need, the U.S. Supreme Court doesn't need to justify its right to review at this point. But there are other things that are happening as a consequence of Citizens United. The McCutcheon case that just came out, for instance, and more is expected.
That's, I mean, totally, I mean, speaking of constitutional regulation, I mean, finance, campaign finance, I mean, it may be a case in point. Speaking of constitutional regulation, that's even more impressive than criminal procedure.
Right, there's a fourth brush.
Yeah, has to be a broader brush in this one. But I don't think, picking up on your question, to the extent that I know, no European country has anything similar. Elections are regulated, some of them are completely publicly financed. There are all kinds of rules. And as a matter of fact, the Conseil Constitutionnel is an arbiter, right?
They ought to be publicly financed.
No, I agree.
You agree?
No, I agree, but in any event, I don't disagree with this view, but what I'm suggesting is that, if I understand correctly, the Conseil Constitutionnel has the final say on an election. It's a court that regulates it. So the whole electoral system in France cannot compare to that of the United States, and I don't think that of Germany or even of the UK, which is the closest to the United States ideologically, can be compared. So Citizens United, I think, looks like a complete aberration from this side.
Yeah, it's certainly equating money with voice, that's the problem. But it's the associational aspect of it that I'm curious about. Much more than getting together as an association and having the right to do that, whether it's spending money on campaign or something else that an individual citizen has the right to do, but the state may claim an association doesn't have the right to do. I wonder if there's any.
No, for us, I mean, as long as, I think that since the law of 1901, I mean, an association, once it is declared, I mean, and only a matter of being registered, can do, has all the legal capacity and cannot be subject to laws. I think it would be, we have never tried. It cannot be subject to laws that some states did have. I mean, the disclosure, mandatory disclosure of membership, mandatory disclosure of finances. Very, very doubtful on these practices, and I don't think that I haven't heard of that in the French government.
We were trying to imagine if something like Citizens United could happen in France. And the answer is yes, it could, because of course there is a limit to the amount of money you can donate to a political party or to a candidate. But then if someone wanted to give more, they could challenge the law before the Constitutional Council with the, you could say, the constitutional issue of constitutionality that we've had since 2008.
Yeah, but they will go nowhere.
Sorry?
They will go nowhere with that.
No, it would not, but they could try.
They could try,
okay,
yes,
so
they
the
could challenge it, but they
though,
will go nowhere, because the
wouldn't they
reason of
consti-
Citizens United is that limitation on expenditures are unconstitutional in the United States. So the whole problem, and the root of the problem is with Buckley. If you stay with Buckley, I mean, there is no way that you can get out of Citizens United, because you stretch Buckley, I mean, as much as you can, and citizens necessarily falls in.
Well, I don't think any
That
European
is why,
court.
I mean, that is why the opinion by Roberts, I mean, is not, I mean, legally speaking and totally from a neutral viewpoint, is not that much objectionable. I mean, if it's true, as Buckley said, that you cannot, under any circumstance, you cannot, under any circumstance, put a restraint, whatever, prior or past or whatever, you cannot put any restraint on speech, because money is speech, because writing a check is speech. Then I don't see, I mean, how you can get out of it. You can prevent, Citizens United.
And I don't see any European court, and you can correct me if I'm wrong, this is just my perception from the other side. I don't see any European constitutional court or Conseil Constitutionnel ever coming to something like that because they all use the principle of proportionality. This is what Breyer is screaming in every dissent.
Yes.
It's totally disproportionate. It doesn't help democracy, it hurts democracy. And I think every European court would go at some point and say, allowing
I
the
was just
richest.
mentioning that the procedure is there.
No, the procedures available, I fully understand. Procedurally, one could challenge, but one would lose, I assume.
There are two reasons. I agree with the argument on free speech, but there is also a big problem, is the definition of corruption. The definition of corruption, I think, is crucial in McCutcheon, and it was already the case in Citizens United. Ingratiation and access is not corruption.
Corruption is just buying something.
Exactly. So you must have a quid pro quo
Right.
corruption. Right? This is totally foreign to the European approach. You need not, a quid pro quo, approach to corruption to say that it is a corrupt practice.
Or corrupting.
Of course, yes. So it's totally different approach of public morality. So there are some cross currents.
Je vais passer le bâton.
Alors donc, second session. So we changed the order, starting with Pasquale. So 45 minutes, including discussion.
So thank you. I could not resist, probably wrongly so, to Bernard Kahn's invitation to participate to this discussion, which is very interesting, by the way. Even though I'm not at all a specialist of criminal law, so I'm going to tell you briefly what is in this draft, which is part of a larger project. It has to do with comparative analysis of something which is somehow known but not systematically explored from a comparative point of view. The object of this inquiry is to try to understand, from a comparative point of view, how opinions or decisions of Supreme and Constitutional Court are produced. Since contrary to what jurisprudence tends to say, there is no constitutional judge. There are panel courts producing opinion. So it's a collective body, everyone in the world, which decided cases or answers questions. And I think it's important to inquire how these panel courts are able to produce an authoritative decision, because with dissent or without dissent, there is one court decision, which is the authoritative decision. That dissent is fine, but it's dissent. It's not the decision. So this decision is made not by a judge. There is no judge. There is a panel. So, in a sense, if you want, I'm interested in how the texts we study, opinions, are produced. We study what is the result of a process which may be called, we called that some years ago with my colleague John Forjon, a deliberative process, meaning that this is the result of an interaction among different individuals, members of the board. So, and this is part of a more general analysis of what I call the morphology of these Constitutional Supreme Court, which has to take into account the mechanism of access to court, the selection of cases, the rule for assigning the cases among judges, the collective decision-making procedure, and the result, meaning the written decision of the court, the authoritative text of law. So, if I focus, as I want to do here, only on the decision-making process, which with my colleague Luis Kornhauser at NYU we call the protocol of the procedure, if you want. Let me sketch out the different steps which we can single out in this decision-making mechanism, on one side in the United States Supreme Court, on the other side in one of the continental courts, the Conseil Constitutionnel. So in the United States, I think that we can distinguish 8 steps. The first one, and I'm taking into account essentially the case of the appellate jurisdiction of the United States, which, as you know better than me, is not the only case, but is the prominent one. The appeal is sent to the Supreme Court from the litigant, the loser of the trial that took place in a circuit court or whatever, or the inferior court. So you see immediately that the United States Supreme Court is a judge of the judges, and not only of statute law. And it makes sense that one of our American colleagues, Mitchell Lasser, compared the American Supreme Court not to the Constitutional Council but to the Cour de Cassation, since in fact, largely from the procedural point of view, the American Supreme Court is a cassation court. Now, the second step is that the appeal is selected or not by 4 judges at least in the meeting that take place for the certiorari. I cannot develop this point here, but it's evident after having made a lot of interview with clerks of the American Supreme Court that clerks play a very important role. So it's a fiction to say that the American Supreme Court has 9 judges. The American Supreme Court has 9 judges plus 4 clerks for each judge. And there are cases where these clerks play a really important role. If you have time in the discussion, I'll tell you how Sandra O'Connor used to make decisions and what role she gave, what huge role she gave to her clerks. And in general, even now in France, where judges have no clerks, the French system is very special. It's probably the only one in the country I know where judges have no clerks. The court has clerks, but not the judges. Well, everywhere in Germany, in Italy, in Spain, in Portugal, in Poland, judges have their own clerks. So the judges, the justices in the United States are their own clerks. So third step is a date which is established for the oral arguments, the adversarial discussion between the parties, meaning their counsels and the justices. This is a very important moment, which has no equivalent in Europe. During the hearing, the justices ask questions to the counsels, and these one and the public start developing an idea of what the single justice individually, with the exception of Thomas, think about the case. There are hearings now in France, there are hearings in the 20% of the cases in Italy, but the judges never move a muscle of their face and never speak. So it's a completely, it would be wonderful to bring students one day to see the oral arguments in DC, and another day it's a nice trip to Rome, looking at what happens in the Italian Constitutional Court where there are public arguments. It's a completely different movie for deep reasons, as you will see. Fourth step, after the hearing in America, the judges get together and a closed door meeting in what are called conferences for a few hours on Friday morning during the session. And in these conferences, in this meeting, they vote on the disposition of the case. They don't vote on the reason given. They have a small machine and they vote like in a parliament, you know. I mean, I don't know if in the Congress you have that, but in the Parliament, I know there are, you push a button.
There are no machines in this.
I've been told by my colleagues that they have a system of voting, mechanic. I mean, they vote no matter what. And this is very important. And they vote on the disposition. This vote is crucial because, as you know better than me, the consequence is that either the chief or the senior judge, if the chief is in the majority, he can do that. If not, is the senior, attribute to one member of the court to write a draft of the decision. So what happens? That the deliberations start only after the vote. Arguments are exchanged not in a face-to-face deliberation, but essentially in written form. In some cases, I've been told by Norman Dorsey, I can't give you the sources of my interviews, all that comes from interviews with clerks, which are much more interesting than judges, because judges don't tell you. So it's pointless.
Clerks lie.
Well, everyone lies, and we too lie.
Unlike the justice.
So this is not specific to any human being.
We have some.
We have to live with that. So, but I mean, if you speak with 25, 30 clerks, you can correct the lie. That's what we do in sociological analysis.
Just a clarification, the voting that takes place, is it simultaneous and final? Or is it sequential? Can one game that as the votes are being revealed?
In the U.S. Supreme Court, they go in order seniority.
Okay, so
Yeah.
it is.
But I mean, yeah, right. But it's the final vote on the disposition of the case, because the case has to be remanded, reversed, or accepted. So it's like a cassation court. Okay? So the deliberation starts after, and with around this draft. And it, according to what I've been told, there is no face-to-face deliberation concerning the reason giving. Once you say reversed, then you have to produce argument after. The justice in the minority at the moment of the vote on the disposition usually write one or more dissent, and they also exchange draft with suggested argument. The seventh step, the member of the majority may produce concurring opinions. And I don't need to explain what is that. 8, lastly, it is possible that the disposition is not supported by a majoritarian or coherent set of arguments, because of the too large number of partial concurring and partial dissenting opinions. In such a possible occurrence, the court's opinion decides the case, as you know, but this opinion doesn't represent a precedent. To represent a precedent, you need to have a coherent majoritarian set of argument. This is why the judge who writes the draft has to make an effort to rally the legal opinions of the member of the majority around the arguments of her reason giving. Okay. In the French Constitutional Council, the type of protocol for the collective decision making is deeply different. Now, we have to distinguish between the saisine parlementaire, the classical mechanism of referral since 1994, which is, in my opinion, I don't agree with many of the French colleagues, this is the revolution, not 71. Because 71, without the reform made by the parliament, would not have been relevant. But in 74, starting from 74, any significant piece of legislation of the French Parliament was sent by the minority to the Constitutional Council.
Starting in 94 or
74.
74.
So that's
When
in
it was
parliament.
60 or, was it 60 or 80 members of the opposition could bring?
60 member of
The opposition.
well, it's not the opposition. The first saisine was sent by the member of the majority, the Catholic. Can I have that? Yes. Right, so it de facto is the opposition, but in the law is written 60 members. So this is the real revolution which was produced by the politicians. It's a constitutional amendment. Now,
It was a promise.
Huh?
It was a promise of Giscard d'Estaing
absolutely, who
during
was
his
political.
presidential
Yeah,
campaign.
right. That's so he was not a judge. Giscard was the president. So, and now we have to distinguish these mechanisms concerning the saisine from the new question prioritaire de constitutionnalité. But the two things have something in common. The two mechanisms. First, the French Constitutional Council, unlike the Supreme Court, cannot choose cases. In fact, they have to answer questions, and this is a crucial difference, which I never saw clearly presented in the comparative analysis. There are no cases. A case is a legal decision. Okay? So a court, Supreme Court of California decides a case, and the case in appeal is referred to the court. Now, in France, there are no cases.
No, it's an ex ante review. You review
Not
all
only-
the facts.
Not only, even the QPC, the judge
I see.
Acquot Dufond, he doesn't send a case, he sends a question. He asks to the council, please tell me if this statute I have to enforce to adjudicate the conflict before me is constitutional or not. So it's before any case decision that a question is sent.
But what is crucial, and maybe I should ask Michel, in the current, the individual question, are they in a concrete question or are they a general question? If you say my client was arrested for saying Hollande is an idiot, is that unconstitutional under Law 245, or is Law 245 unconstitutional?
The second.
The second,
Okay.
the second is a law, is a law.
Okay,
It's
And
not a
there's no
case.
facts ever included in the question.
right.
The facts
The
are,
Constitutional Council does not know the facts.
exactly.
Does not
And-
know the facts.
Well, they may know or not, but I mean, what is sent to the council is a question, okay?
But just one thing. In the U.S., it is a question presented in the sense that there are only certain there are certain questions within the case that will get to the court.
Not the whole
No.
case.
It's not the whole case, but it's a question that was certified somehow by the circuit court or something like that. So it is also a question, though it may be different in its form.
The
And
question may
if you talk
be,
about, if I could just add, and if you talk about constitutional review, it's only a constitutional question, because the Supreme Court is a general court, it can decide a
Exactly.
question of federal law, it's not a constitutional question,
Exactly.
but if we do the parallel with the French court, then we should only count the constitutional questions presented to the US Supreme Court, which may be part of a case.
Right. But to the Supreme Court, the question is not sent as adapt. What is sent is a judicial decision. No judicial decision is sent to the Constitutional Council. You understand the point?
Can I ask-
I mean, you sent a text written by a court. We never can send a text written by a court.
But the question is, what is the relevance of this? If the Supreme Court only considers the question of does it violate the First Amendment to do X, and the case has all kinds of things.
Okay, to understand what
But
is
it
the
doesn't deal
consequence
with
of
it.
that, we need to know what is that. You cannot answer the question, what's the consequence of something, if you don't know the something. So I'm trying to figure out what is the something. And then we will see. No, because I mean, you have to answer a question. So you have to put on the table what is the question. So the question here is that the American Supreme Court has cases, and these French and Italian, and in many cases the German, not in all cases, is a question. So now, at that point, in France, the QPC go through a filter mechanism, but that's not crucial for me. The second step is that the president of the French Constitutional Council has, in any event, a discretionary power with the Secretary General. Sometimes it's the Secretary General. Depends on the quality, the intellectual quality of the president and the Secretary General. So we have to enter in the individual details, because institution exists because humans man these institutions. There are no institutions, human institutions, without humans. So unfortunately, we need to know the humans. Okay, so the president, in theory, has the discretionary power of assigning the question of constitutionality to one of the members of the panel court. Now, this person, the juge rapporteur, plays, or at least may play, if he's competent, a very important role in the discussion of the question. In France, the name of this juge rapporteur is not known. Everything in France is produced of a collective, anonymous body called Constitutional Council. Okay? So that's a basic difference with the Supreme Court. When I interviewed my colleague Norman Dawson, and I was asking what the Supreme Court does, and Pasquale, stop asking stupid questions. There is no Supreme Court. Ask me what the judge X or the judge Y was doing. We have judges, we don't have a court. You don't understand the United States. And here, I mean, there are judges, but we don't know what they do. Now we know what they said, because this country is the only one in the world which now has decided to publish the secret deliberation in their integrality. 25 years after the deliberation, the documents are public. So now we have the procès-verbal, I mean the proceeding of the entire secret debate. So we start to know a lot. And we will know more than any other court. Huh?
Provided they give you the whole file.
Well, if they don't respect the law, I feel in Italy and not anymore in France. That's too bad. I made a mistake moving here. I tend to believe
I
that
have some doubts
this
that
is
they
a-
always give the whole file.
I mean,
Because
it's,
when you see
you're
the
right.
book that was published on the Grande Délibération du Conseil Constitutionnel,
this is partial.
there are some big holes.
You're right.
in this.
You're right. But
That's
I,
171.
yeah,
Exactly.
yeah. But that's why I send my
And
student to
nationalism.
look at the archives.
And the
Yeah,
nationalism.
yeah, you're right. I mean, these are partial, but this is not the archive is a publication, which is partial. Okay, so now what is the point? The interesting point is that in France the mechanism is such that the decision concerning the disposition is produced after a debate on the reason given. So you don't vote on the disposition here. You vote on the arguments. if you vote. Sometimes you vote, sometimes you don't vote. Now we can look. We have all the documents until 25 years ago. And in many cases, I mean, there is a student of mine writing a dissertation, so I can tell you more in some months when I read accurately her work. So, but what is important, and depends on the protocol, is that the decision concerning the disposition of the case, in which case the disposition is constitutional or not, is partially constitutional, that's at the end of a debate. Where in the United States there is first the decision on the disposition, and then there is a production of arguments. So we believe, I say we because that's what Louis Kornhauser thinks, and he has probably already published something on that, but he has published years ago a couple of important articles with Larry Sager on what they call the discursive paradox. I mean that with the American system you may have cycling majorities. So that the majority of the disposition may not coincide with the majority of the reason giving. This is not possible in France, because the reason giving is the result, the final result. I want to stop here just saying that there is something specific of the French case, is that unlike the Italian or the German court, the French Constitutional Council has to make its collective decision under time strong constraints. They have, for the saisie parlementaire, 4 weeks, de facto 3 weeks, and for the QPC a bit more, but they have many QPC now. So what happens? It happens that when they enter into the conference, this is more or less the day before they have to publish the decision. So the juge rapporteur has to go there having the certainty that there is an agreement. Because if there is no agreement, I mean, it's a tragedy. They have to publish the day after in the Bulletin des Lois. So in fact, before the meeting, through the work of this legal service under the direction of the Secretary General, which is a very important figure. We say that we have here 10 judges, 9 plus the Secretary. So with help with the Secretary, who has 30 clerks. Now, it's recent, okay? They have to produce a text and find an agreement, mostly before starting the debate. This is different in Germany and in Italy. In Germany, there are deliberations which last months. The famous Lissabon-Urteil, the decision on the Lisbon Treaty, was discussed in the Bundesverfassungsgericht for 6 months. Yeah, that's an important decision. And they have few collective decisions. Most of the decisions are made by a panel of 3 people. I mean, that's a different story, a different protocol. So I stop here because I want just to say that this comparative analysis, even though everyone knows more or less all these things, telling you know, the French know very well how does it work in France, you know better than me how it works in the United States. But I believe that it's useful to compare, and expanding to notably to Germany and to Italy, at least because there are variations of the French case. The French case is the prominent. What is characteristic of the French case is no dissent. In Italy, like in France, there is no dissent. So it's really a collective body. There is the idea that the decision is made at the end after analyzing the arguments, and that depends on the cases. There are more or less time constraints and no certiorari. So I guess that this may be a useful set of information to develop our knowledge of constitutional jurisdiction. It for the normative or philosophical theory of what is the good model. Perhaps we should learn something about the real model, and then may say something about what is better. But if we don't know how it works, I mean, I think that theorists have been always trying to change the world. I think that they are first to understand the world.
So we have now 20 minutes of discussion.
Yeah, I want to, and hopefully you can reassure me, want to be very skeptical in the following sense. If I understand the way, and I wasn't a clerk, so those in the room, I guess you were a clerk, but you could perhaps enlighten me. Is that it's true that the deliberations of the Supreme Court may occur after the judges have decided where they stand, but there are cases in which they change. It's not as if the deliberations are the final, so that the process of arriving at, there are even famous cases in which a judge switches sides and somebody else has to write the opinion and so forth. So the process of deliberation as such is not over until they have a conference and so forth, so that they have opportunities to change. On the other hand, the one phenomenon that strikes me about the French system to be crucial from in terms of how do they produce decisions is that, and this was quite striking to me because it was told to me by a then member of the Conseil Constitutionnel, is that he was rapporteur of case X, but he was in the dissent. So it's really the institution that speaks, not the individual. So they had voted, let's say, 5-4 in favor of X rather than Y, and he voted for Y. But since he was assigned the role of so, and there is something very formulaic. If you read decisions of the French, the one big difference between constitutional court, the U.S. Supreme Court constitutional decisions and the French Conseil Constitutionnel, and now it's a little less. Lasser brings this out in his book very well, is they're very formulaic, they're very institutional, whereas Law 66 says that, and then Article 4 of the Constitution says that, we conclude that. Whereas if you look at the today's decision by the U.S. court, there's sagas, there's story, this and that, and the slaves suffered terribly here and there, and I come to this conclusion. The other justice, not at all, racial equality was achieved 100 years ago, we don't have this problem. But look for instance, the dissent of Sotomayor in the Michigan affirmative action case, where the majority of the court said that Michigan by referendum can abolish affirmative action. So it's true that there is a much more subjective side to Supreme Court decisions. How much that has to do with culture rather than process is to me, an important question. But in terms of the deliberation itself, is it so different if you take into account the fact that one allows for individual expression and the dissenting opinions are welcome, etc., and the other one does have to end in an institutional decision? But what I'm talking about is the deliberation, the part that the judges have to do with one another. Judges meeting as a body and discussing. I mean, and somewhere or another, whether it's first through oral drafts or written drafts, or whether it's a formal meeting, judges have a case, a question, whatever it is in front of them, and they deliberate in both cases. Or am I missing something?
Well, but they deliberate as following different protocols. That's what I was trying to say. Go on.
No, I have a question of complete ignorance. I find it hard, because of my parochial orientation, to think about constitutional issues being presented in the abstract. I understand that in the United States we have mechanisms where we call them certification, where, say, a federal court will pass on to a state court a pure question of state law to be answered, and after which the federal court will go on its merry way. So I understand the concept of a pure question of law. I have a hard time understanding constitutional development and this is purely my ignorance, but how does the way we use, in the United States, we use the embedded nature of law in a factual context as both a limiting factor and an extending factor, right? It's a limiting factor in the sense that you're working within the contours of a particular set of facts, but it also allows you to, with reference to facts that aren't before you, start signaling where you might go in the future or where you won't go in the future. There's a plasticity to the development of doctrine that, from my mind, comes from the embedded nature of the law within the facts. And in my parochial view, a court like you're telling me that the French Conseil d'Etat that doesn't have that kind of embedded nature is either going to speak an awful lot or going to speak very little. I don't understand which way it would break. It could speak an awful lot in the sense that every law that's presented, if it, let's say, to use the example given, involves the constitutionality of a statute that might, the constitutionality of a statute speaking to speech of some sort. If we take out what the speech was, and the statute always has to be viewed in terms of all possible speech, the way we think of sort of a general facial challenge, then the court might almost always curtail the application of the statute, because one could imagine some troubling applications, or one could conversely imagine that the court is very reluctant to bar a statute from extending into what might be permissible application. So I don't.
So can I sharpen that question? That was exactly my question. So we have two kinds of challenges: facial challenges to statutes and challenges as applied. Challenges to as applied are the ones you described. You know, would it be unconstitutional to say that this speech is banned? But a facial constitutional challenge means, is there no set of circumstances in which this law could be constitutional? Now, there's a third kind of challenge you could imagine that we don't have, which is, here's a law, is there any set of circumstances in which it might be unconstitutional? And, you know, thinking of anything. So when the Conseil Constitutionnel is asked, is this law constitutional? Does it say, well, it would be constitutional in these kinds of cases, but not in those kinds of cases? Or it's at least constitutional sometimes, so therefore it's okay. Or it's at least not constitutional one time, so therefore it's not okay. So what do they do?
Yeah, I've been thinking for many years about these questions. I will give a telegraphically short answer. Americans have a theory of constitutional adjudication, an abstract theory, very similar to us. There is no, if you look at Marshall regional text, which is a piece of theory, and Kelsen theory, which is our starting point, they are very similar. They believe in a hierarchy of norms, so that the inferior norms has not to contradict the superior. But that's theory, and the Americans do not care very much about that. They have a very rich, huge tradition of judicial review, which has its roots in the common law tradition. So they don't care about their theory. You invented our theory. Kelsen rediscovered that without knowing the American theory. But you don't care about your theory. You care about the real process of the secular now, process of constitutional adjudication you described. We had no tradition, but we had a wonderful, systematic, organized theory produced by this Austrian legal theorist. Very important here, even though he spent most of his life in the United States, he could not speak English well, so he was never taken very seriously. So our theory says that the task of the Constitutional Court is to check if statute law is coherent with the constitutional provision. is what the professor does, you know. So you have the right answer, and then there may be a deviation from the right answer, and if there is a mistake, there is a mistake. Okay, it's a pure logical doctrine. If you read Kelsen, I mean, it's controlling coherence. That's the theory we took seriously because we had no practice. We had a wonderful theory and no one doing that. When Kelsen did it, they kicked him out because he was a Jew and he was liberal, so he finished rapidly the experience of the Austrian. The constitutional adjudication in Europe is younger than me.
I won't ask.
No, that is younger than 49 in Germany. Okay, I was born in 48, so it's younger than me. And there was nothing before that. But Kelsen, nothing relevant. There were some elements. But Kelsen wrote this theory in the 20s. Important books, very well known books. So this is an important difference. You did not take seriously your theory. You took seriously your practice. We took very seriously our theory, which was the same, because we had no practice. Now, in the concrete development, notably in Italy and in Germany first, and then now in France with the QPC, what happens? Something which is a mix. Because when, in theory, the judge in the QPC, he has to judge the law, but they discuss the law in the context of its enforcement. It's not a law which is challenged a priori, like in the saisine parlementaire, where you can only try to see if it's coherent. Then, I mean, I don't think we can use this parallel facial and as applied. This is misleading. It's a bit complex, but I'll try to clarify that at some point. I don't think, I mean, it's a different system, where our system either is very abstract, when the law is challenged a priori or is challenged outside of a trial, or mixed, because when Justice Canivet has to judge a QPC, he looks at the concrete case. He's not asked to do that. But he has to, he tries to see what is, because what's the problem of these guys is to avoid injustice. Injustice is something which is concrete. There is no abstract injustice. So notwithstanding the abstract structure, more and more, they look at the reality. Not in the case of the saisine parlementaire, because in the saisine parlementaire there is no case. Well, they have to anticipate what happens enforcing the law, because I mean, I don't believe in this pyramid of norms. This is a theory. What a court does is try to avoid injustice. Injustice is what is produced enforcing the law. If you don't enforce the law, there is no injustice.
Can I give a concrete example? Because from a practical point of view, maybe I'm just being an American naive, I don't find so much different. This is an actual case of the Conseil Constitutionnel after 1968. There was a reform in the whole educational system because of the Revolution in 68, and they had councils where they put professors and assistants and probably the janitor. So to make policy, they had councils in general running the new reality in French universities. And that was challenged in front of the Conseil Constitutionnel, which said that violates the equality rights and academic freedom rights of professors, okay? Now, there are no facts. It's not John Doe sitting with Jane D. But in fact, it's a fairly concrete problem. Are professors in a university different than janitors and student assistants? When you sit together to do curriculum, should they have the same voice or not? How is that different from our average case? Not that different.
Well, when you have the janitors who are unionized, I mean, it can be a serious threat. I mean,
No, of course, I understand. So you're giving even more facts, but my point is that it's occurring in a social reality where what I would call fact and law are present. These are social facts about roles in a French university which are known to the Conseil Constitutionnel when it makes its decision. That's all I'm
But
saying.
here's my question. So you could imagine the court saying, well, those rules are not so different when it comes to deciding what should be served in the cafeteria, but they are different when it comes to deciding the curriculum of the classroom. So you could imagine them saying, no problem with putting them on councils that decide certain matters that are, you know, but, you know, so then they're sticking in, they're doing what we do and say, it's okay for these facts and not for those facts. Is that what happens?
Yes.
Different councils.
Yeah.
So then it doesn't seem.
But there are no
as-
real facts. See, I think
But
that's
so they're
the
making them
hang
up.
up, is that there are no real facts. We have a real fact because we have to have exposed it. Where John Doe was denied, right? Alan Baki, a man, was denied admission to the medical school on an affirmative. But you could have the same affirmative action decision that there are white men in society, there are rich African Americans, poor African Americans,
Right.
Latinos. We can have it on stereotypical interpretations of roles as opposed to this individual or that individual. But at the end, it's not that different, I think.
So they are facts that they can imagine, but they don't mention the facts, and they don't have the facts that is brought to them.
Right.
And what they do, and this I must add, is that even in abstract review, they will add in the decision a sentence, say that the law is constitutional, provided that it's interpreted in a certain way. But if interpreted otherwise, then it's unconstitutional. And this, there's been a lot of discussion, but this is supposed to be binding on the lower courts when they apply the law.
So that makes it more similar.
Yes.
But I think that, I mean, we're getting a little bit away from, I think, what Pasquale was trying to focus on, I think. I mean, because this is something that we in the US are surprised by. But I think that, I mean, the place that I think Pasquale's intervention gets at is some of the other more technical procedural protocols and what implications they might have. And the one that I think is the most striking to me is the idea of the anonymity of the judge. Because there's got to be a huge effect to the fact that you are not developing your own jurisprudence. Right? You have no opportunity to develop your own jurisprudence.
That's crucial.
And that seems important.
That's crucial.
Because it's gonna, I think there are gonna be game theoretic implications to this. I look at Rick because he's the expert in that area, among other expertise areas. But I think that there would be very different ways in which one would align, vote, write, etc. if one is taking the institution, knowing that it's just the institution that's speaking, not thinking that these deliberations are going to be released.
It's back to Justice Kennedy, let's imagine, you know.
Right.
But that's
right.
exactly the
Right.
point of my paper. What
Right.
you are saying.
But then the question is, what does that make you do, right? So how does it make you slightly change your vote, or not get so concerned about confrontation, right? You don't have your own confrontation clause.
There's no brand
interpretation.
development.
You've got no brand development.
So
Right,
I'm
right,
guessing that
right.
judges of the Conseil Constitutionnel are not writing like judicial biographies of them, autobiographies of themselves, like Sonia Sotomayor
Right.
and Stephen Breyer, who write about their vision of the, you know, world and their histories.
But
There's
doesn't
no
it depend
cult
on
of
whether you
judicial
are a Brennan or a
personality.
Scalia? If you're Scalia in the American Supreme Court, you say, I don't care whatever they say, I want to have my view
Exactly.
of the original thing. So that doesn't exist in
They
Conseil
teach
Constitutionnel.
from the bench.
Yes,
Exactly
that
what
doesn't
I-
exist.
Scalia is not interested in doing compromises.
Right, right.
He's
Right.
interested to speaking to people outside. So with
But
Fred John, we
O'Connor
spoke
and
of
Brennan,
external
though, would be different than
deliberation.
the French
Yes.
judge. That's
They
the
send
important question.
signal their
The
personal,
consensus
as
vote.
Bernard was saying. I mean, where Guy Canivet, what is the jurisprudence of Guy Canivet? No,
That's
I
a
don't.
real cult difference.
This is
But
a
it could
crucial-
mean
How does
that,
that
right,
affect them?
it could mean that you have less investment in particular doctrinal developments
Sure.
right? You're not going to hold out or something.
You might, but I mean, here's where the game break is. If I have a vision of the good, and I'm a French judge, I understand that there won't be brand development externally. I'll take the assignments I have. I'll be a good soldier in terms of my writing, but I still have a vision that may differ from yours, that I'm trying to promote.
Yeah.
And you say that there are regular votes on each case. So I understand that at the edges, this will curtail my entrepreneurial instinct in terms of the opinions I write. But I still have some interest, since I want to promote my vision of the good, for maintaining my vote and telegraphing to you internally that next time around in a similar case, I will be taking a similar position, and no or yes.
Yes, but I tend to believe that possibly an important consequence of the absence of this public persona is that these non-visible voting, because we know what your judges vote, and here we don't know. So the consequence is that they may be more prone to compromise, to find a collective decision, where an American justice may say, well, after all, what is my job is to show that I have my jurisprudential doctrine. And I lose the case, but it's not the most important case. Where if you cannot project outside your persona, you may, at least that's what I've been told I've been also told that they have a flexibility that they could not have if the vote was disclosed. Suppose you are appointed, as it is here the case, by conservative politicians. If they see that you vote with the liberal, I mean, it's tricky for you. But if nobody knows, you have more possibly. I mean, they don't have to care about their image.
So we have a double polarizing effect. We have not only the selection of judges from lower courts based on who they are and what brands they've developed, but once we bring them inside the court, we allow them to continue brand development.
Exactly.
You have neither of those, or you would have neither of those things. You would have a judge selected. We don't really know what his flavor is very well, because he's been operating at a different, and he's also coming up through a culture that I assume is much different from the United States. Your legal culture is much more, I'm guessing.
Depends on the countries, but I tend to agree. France is a bit different, but this is Germany and Italy. Yeah.
So we much more homogeneous, much less signal giving before you get on the court. Once you're on the court, there's much lower reward for signaling in terms of developing your persona as a legal. So all of this pushes in the same direction. That's really interesting.
And in my normative position, but I cannot develop it here, is that a court has to decide in the middle. So this close deliberation is easier. In fact, I mean, it happens also in the United States most of the time because of the crucial role of the median justice.
Most of our cases are very boring.
That's true.
Well, I mean, I don't think that the French or Italian cases are less boring. Why do you think so?
Can I ask a question? Is there as strong a norm in the Constitutionnel of stare decisis? Because
Sure.
that's the thing that disciplines the individual branding of justices. They can beat each other up with the commitment to stare decisis.
Stare decisis exists everywhere.
May I step in, please, follow up after Carol's questions. This is a very important question. And this is the reason why we have this abstract judicial review. Because that was a necessity, considering that we have no stare decisis in the entire legal system. So therefore, we have no stare decisis.
As a theory, yeah.
Well, as a theory, we have la jurisprudence constante, but la jurisprudence direct means that judges, do follow a pattern. Do follow a pattern. But they may feel free, to step aside if they do not agree. And then we have Court of Appeals, for instance, which get into rebellion against, this is what I told you,
Yes.
Sprech. So therefore, since we had no stare decisis rule, it was absolutely necessary when the idea of judicial review of statutory law was introduced in Europe. It was absolutely essential to have a centralized mechanism for adjudicating these issues and to be sure that the answer that would be given by that centralized institution would be applied all across the board. So this is the reason why we have this abstract judicial review, and this is very well explained by Dr. Goldbach precisely in the Journal of Public Policy in 1942.
I'm sorry, we're running out of time now. Jean-Louis has just asked for
There is some talk.
It's in 5 minutes.
I would like to say that there is something very important in what Pasquale has said about today's subject, penal and criminal justice. That the difference between the French Constitutional Council, which decides about statutory laws and about statutory texts, and the US Supreme Court, which decides about cases and about rulings made by judges. I think that for criminal law, the consequences are very important. It seems to me that the case law of the Constitutional Council about penal law and criminal procedure is not so developed and rich. Many times when existed only the ex-ante and abstract judicial review, before 2008, 2010, in many cases, the Constitutional Council has said that the new statute about penal law or penal procedure was not inconsistent with the Constitution because there was a general respect of the principle of proportionality, and in the absence of case and concrete case, they could not say that the new penalties were too hard or created a new injustice. And they were very cautious in striking down penal laws or penal process. What can be compared with the role of the American Supreme Court in criminal justice is, as Pasquale has said, the role of our Court of Cassation. Because if the Court of Cassation, and it has happened many times in the French history from the beginning, it's the Court of Cassation is saying that one way to apply the penal law or the penal code of criminal procedure is not legal. It means that all the criminal process in this case is quashed, and that probably, especially if the Court of Cassation repeats the same case law many times, it means that the judge cannot continue to apply the same way of processing. They must take account of the ruling of the Court of Cassation saying this way to ask the jury, this way to deal with the police procedure, this way to decide with the judges of inquiry is not good, and we have to abandon it. And in some cases, the decision of the Court of Cassation can create a sea change in the criminal procedure, because after the decision, there is a new way of process. The decision of the Constitutional Council has only a direct impact on the Parliament to prevent the Parliament to take a new law that could endanger human rights and the principle of the Constitution. But it has no direct impact in the penal process today. What happens in police proceedings, it's what happens in the before the juge d'instruction, it's what happens in the court d'assises. It's a little answer to your question.
Right.
What are the consequences?
That's very helpful, yes.
So one last question.
Okay, I just wanted to bring it back to that earlier conversation about generalizing. Seems a very large difference between two systems is in the promotion of individual legacies or personality branding, as we were talking about. And I wonder if we can take those general themes and sort of deduct these seemingly technical differences in procedure. So for example, take the voting example. In the US context, it's as if each party is already, right, because first they cast their vote, and then they sort of rally the troops by trying to persuade each other, well, kind of come join my side, and that seems more of like a sort of inevitably politicized, even internally, process of vote gathering that might come from this sort of system in which people are developing their own personal jurisprudence and stuff like that. Whereas you gave the example of the seemingly much more bureaucratic, anonymized procedure in which right, we come to a decision, and then after that, it's as if you weren't even, your identity didn't even matter in the first stage, and you might be assigned to write the formulaic opinion. So it seems like these procedural differences might come directly from that.
And this is interesting. I don't need to answer. I want just to add that these two procedures have to do with very old traditions. The French model originated in an ordonnance royale of François Ier, 1570. And the American model originates in the mechanism of collective decision-making of English courts in the Middle Age, seriatim. So, has to be studied. I don't like the word culture, I like the word history.
If I could, one very quick final comment to this. I wouldn't go too far. I know one French constitutional judge who felt passionately about something, had worked on it, and tried to persuade his fellow constitutional members, just as the American Supreme Court would. You're right that there is not this sort of public persona aspect of that, but the idea that there's no vigorous debate or that people don't bring personal experience, I think would be.
You're right. You're right.
And vice versa, I think that's true. Because there are some decisions by the Supreme Court which are the best.
Yes, that's right.
So we want to be fair to them.
Yeah.
Do we need a leg stretch? Do we need a coffee?
Yeah,
Do we need-
5 minutes.
Okay, yeah, because we have some people who just came off the plane yesterday.
Thank
So,
you.
very